Secretary Bellows, there are people all over the country, independent groups, other secretaries of state, judges, legislators, lawyers who are watching you right now. Are you expecting to, or have you prior to this decision, has anyone reached out to you? Have other secretaries of state reached out to you and said, hey, how did you, I'm struggling with this. Could you help me as well? Or is this a decision that you're saying, hey, everything that I think is in this written decision, and I'm not really open to providing, counsel or assistance to any other states that may be struggling with this issue?
That's really important. The latter is the case. This decision is based on Maine law and the facts that were presented to me in the Section 336 challenge. It was really important to me to look at the evidence presented in the public hearing and the law and the facts presented in the context of Maine law, sections 336, 337, and 443. It's a very detailed decision. We lay out why under Maine law, the Secretary of State has the authority, indeed the obligation, I'm duty bound to make this determination. I laid out that the record demonstrates that, in fact, the events of January 6, 2021, which were unprecedented and tragic, were an insurrection in the meaning of Section 3 of the 14th Amendment. And finally, in reviewing the facts presented, the evidence, the law, the history, we determined under Section 3 of the 14th Amendment that Mr. Trump engaged in insurrection and therefore was disqualified.
So one of the things that you mentioned is that since anyone within a certain period of time can challenge a candidate's eligibility, you had people present the case that Trump should be off the ballot. And obviously you had people present the case that Trump should remain on the ballot, right? You had people from both sides making this argument. So here's my question. And I wonder if this sort of came up because it's always something I've questioned about sort of the Trump argument. Donald Trump claims that he was elected in 2020 and that the election was stolen from him. I mean, my understanding of the Constitution is if you've already been elected twice, you're not allowed to serve again. How did you deal with some of the arguments that you heard from the Trump side? And do they have an opportunity to appeal if they're unhappy with your decision?
Certainly. Mr. Trump was represented by counsel. This was an administrative hearing. I was serving not as an advocate, but an adjudicator, as an administrative hearing officer in the hearing. And Paul Gordon was one of the three challengers who brought a challenge, and he brought it under the 22nd Amendment, alleging that because Mr. Trump has said publicly that he won in 2020, that he was disqualified from appearing on the ballot under the 22nd Amendment. My decision also found that the facts were not in dispute. No party suggested that Mr. Trump had in fact won in 2020, and the 22nd Amendment did not apply in this case. There were other challenges brought by Marianne Royal and by a group of former senators, former Republican State Senator Kimberly Rosen, former Republican State Senator Thomas Saviello, former Democratic State Senator Ethan Strimling, and those challenges were brought under Section 3 of the 14th Amendment. And that is where my ruling did, in fact, find that Mr. Trump was not qualified for ballot access in Maine.
Maine Secretary of State Shenna Bellows, thank you so much for the serious work. I hope you stay safe, and I hope you stay committed to the work that you're doing for this country. Thank you.
Thank you.
The right to vote is fundamental to everything else that we care about. Our democracy depends on every American citizen being able to participate and exercise the right to vote, to hold those in power accountable for decisions that are made, and to make sure that our government is representing the will of the people.